welcome to online study of Indian Penal Code. Today we discuss the provisions of section that is 410 of the Indian Penal Code, which defines stolen property. What is stolen property? As a layman, when it is told that you understand stolen property, that the property which has been stolen, but that is not the case. It has been mentioned in section 410 of the Indian Penal Code that if the possession of any property, the possession of whereof has been transferred either by theft, extortion, robbery, and property which has been criminally misappropriated, any property which has been criminally misappropriated, on respect of which criminal breach of trust has been committed, is designated as stolen property. What section 410 says? What is stolen property? The property, the possession whereof, ownership is immaterial. The possession of that property has been transferred. How? Possession is transferred from person to person. Possession of a property which has been transferred, probably almost movable property, of theft, extortion, or robbery. Theft, extortion, or robbery. Or the property which has been criminally misappropriated. Criminally misappropriated, you know, property. Dishonest misappropriation. Appropriates. That is criminally misappropriated. Or the property in respect of which a criminal breach of trust has occurred. There is a criminal breach of trust has been committed. That property is designated as stolen property. Whether the transfer has been made or the misappropriation or breach of trust has been committed within or without India. Even whether the transfer has been made, the possession has been transferred either within India or without India. Or criminal breach of trust or criminal misappropriation has been committed in respect of that property either in India or beyond India. But if such property subsequently comes into the possession of a person legally entitled to the possession thereof, suppose a property, the possession of that property has been transferred by theft, extortion, robbery, or a property which has been criminally misappropriated, or a property in respect of which the criminal breach of trust has been committed, that will be designated as stolen property. But subsequently, if that property comes into the hand of the possession or comes to the possession of the person who is legally entitled to possess, that property will no longer remain as stolen property. So you should understand the provisions of section 410. What is stolen property? Stolen property is not the property which has been stolen. No, that is layman's understanding. But section 410 of the Indian Penal Code provides a property, the transfer of which has been made either by the property, possession has been transferred by theft, extortion, robbery, or any property in respect of which a property which has been criminally misappropriated, or any property in respect of which criminal breach of trust has been committed, that is designated as stolen property. It is immaterial whether such transfer has been made or criminal misappropriation or criminal breach of trust has been committed either in India or without India, beyond India. Then again it has been clarified in section 410 that If the possession of the property which has been designated as stolen property, that comes to the possession of the person who is legally entitled to possess, then that property will no longer be designated, no longer be treated as stolen property. Now you are clear. Section 411 says, dishonestly receiving stolen property. What is it? Whoever dishonestly, you should, whenever the word dishonestly is used somewhere, you should understand the meaning understand the meaning of that word dishonestly with reference to definition in this section, in this Indian Penal Code. That is causing wrongful gain to somebody and thereby causing wrongful loss. Wrongful gain, gaining of property of a property by a person of who is not legally entitled to gain. Losing of a property by a person for which he is not legally entitled to lose. So that is dishonestly receiving stolen property. Whoever dishonestly receives or retains, either receives or retains any stolen property, knowing or having reason to believe the same to be stolen property. First thing, if suppose I receive this property, that is stolen property, but without knowing that it is a stolen property. So in section 411 will not be applicable. So if a person either receives stolen property or retains stolen property, knowing or having reason to believe. Knowing means he knows it. Having reason to believe. Having reason to believe, that is to be considered, that is to be that is to be inferred from the circumstance of the case. Suppose a person sells a gold necklace of weighing 20 grams to another and offers to sell it at a price of only 30,000 rupees. So here there must be a reason to believe that it is a stolen property. If a person receives or retains stolen property, knowing the same to be stolen, or having reason to believe the same to be stolen. Suppose in a very low price somebody offers to sell any property much lower than the market value. Then there should be a knowledge. The person should infer, the person who receives or gives that property must have a knowledge. He should have reason to believe that it is a stolen property. So if a person receives or retains stolen property, knowing it to be stolen or having reason to believe that it is stolen, then he is liable for punishment with imprisonment of either 2 years for a term, it may extend to 3 years, or with fine, or with both. That is section 411. 412 says, dishonestly receiving property stolen in commission of a dacoity. When a stolen property is also a dacoity property, because what is dacoity? When robbery is conjointly committed by 4 or 5 or more persons conjointly, or the number of persons which do commit robbery were in a group exceeding 5 and more, then that will be dacoity. So when that is dacoity, whoever dishonestly receives or retains any stolen property, the possession of whereof he knows or has reason to believe to have been transferred by the commission of a dacoity. Whoever receives or retains any stolen property knowingly or having on with an intent knowingly or having reason to believe to have been transferred by commission of dacoity, or dishonestly receives from a person whom he knows or has reason to believe to belong or to have belonged to a gang of dacoits, or if a person dishonestly receives from a person whom he knows, if a person knows that person or has reason to believe to belong to a gang of dacoits, which he knows or has reason to believe that he belongs to a gang of dacoity, property which he knows or has reason to believe to have been stolen, dacoit, from a person whom he knows that he belongs to a gang of dacoity, or he belong to a gang of dacoity, and knowing that that is a stolen property, which he knows or has reason to believe to have been stolen, shall be punished with imprisonment for life or with rigorous imprisonment for a term which may extend to 10 years and shall also be liable to fine. Section 400 will be applicable when a person receives or retains the stolen property, knowing or having reason to believe that the possession of that property has been transferred by dacoity, or when he receives that property from a person whom he knows that he belongs to a gang of dacoity, then and also knows that the property which he receives, that is stolen property, then in such case he is liable for punishment for imprisonment for life or imprisonment which may extend to 10 years and shall also be liable to fine. Section 413, habitually dealing in stolen property. Always you should bear in mind what is stolen property. Habitually dealing in stolen property. Whoever habitually receives or deals in property, receives or deals in property, you are not retained. Habitually receives or deals. Deals means what? Dealing, that is somehow or other, is transferring, is cunning, that is selling, or whoever habitually receives stolen property or deals in property, which he knows or has reason to believe this seems to be stolen, shall be punished with imprisonment for life. Here, that is, a life imprisonment is there. Whoever habitually receives stolen property or deals stolen property habitually, knowing that it is stolen property or reason to believe that the same is stolen property, shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and also be liable to fine. 414, assisting in concealment of stolen property. In some case, sometimes, some goldsmith, when a stolen property, somebody brings a stolen property and approaches goldsmith to a gold ornament and approaches a goldsmith to make the ornament, so that what the gold stolen property will be concealed. Or even if somebody assists in concealment of the stolen property, that is punishable under section 414 of the Indian Penal Code. Whoever voluntarily assists, voluntarily is very important, voluntarily assists in concealing. Suppose somebody compels somebody, you do it, or conceal it. That is, this section 414 will not be applicable. Whoever voluntarily assists in concealing or disposing of or making away with property, making away with property, concealing, disposing of, making away, that is a property which he knows or a reason to believe to be stolen away. That is, to change its making. Whoever voluntarily assists in concealing or disposing or making away of the property with property which he knows or reason to believe to be stolen property shall be punished with imprisonment of either disgrace of a term which may extend to 3 years or with fine or with both. This is 415 is a very important provision. Very important provision. Sometimes we say cheating. For cheating, you should always keep in mind, for cheating there should be a deception. Somebody will deceive something, another person. On facts, some deception will be practiced, and by that deception, there should be an inducement to the person who has been deceived to deliver any property to him or to any other person, or to give his consent for retaining any property, or to do anything which he would not have done if had he not deceived, or omit to do something had he not deceived. Such which act, that act or omission must cause. Omission must cause is likely to cause to damage, harm to that person in body, mind, reputation, or property. Then that will be treated as cheating. So if you go through the definition, word by word, cheating, section 415 is defined, but sometimes it's a very important provision and creates a confusion. Without understanding the definition, sometimes even the subcontractual liability brought under section 415. What it says? Whoever by deceiving any person. What is deceiving? deceiving, misleading by concealing certain facts. That is deceiving. Whoever by deceiving any person, fraudulently or dishonestly. Fraudulently has been defined in the Indian Penal Code with intention to defraud. That means he must get some benefit out of it. Not otherwise, with intention to defraud, not otherwise. That is intent to cause loss, financial loss to another person and to gain. That is with intention to defraud. Whoever by deceiving any person, fraudulently or dishonestly causing wrongful gain to himself and wrongful loss to another, induces the person to deceive. First thing, by deceiving any person, there is a deception. Whoever by deceiving that's concealing certain facts and thereby misleading. Whoever by deceiving any person, fraudulently or dishonestly, fraudulently that is to be understood in the as defined in the code, in the Indian Penal Code, with intention to defraud, or dishonestly causing wrongful gain or wrongful loss, etc., wrongful loss to another, induces the person so deceived. Thereby he induces the person so deceived. What? To deliver any property to any person. That will be treated as cheating. Second, or whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to consent that any person shall retain any property, that will also be treated as cheating. Then whoever by deceiving fraudulently or dishonestly induces a person so deceived, or intentionally induces the person so deceived, or intentionally induces the person so deceived to do or omit to do anything which would not do, into unintentionally, which intention is there, or intentionally induces the person. Your or is there, or intentionally, whoever intentionally induces the person so deceived, there must be a deception. Whoever by deceiving any person fraudulently or dishonestly induces any person, or intentionally induces the person so deceived to do or omit to do anything, either to do a particular act or omit to do a particular thing, which he would not do or omit if that person would not have done or would not have omit to do if he was not so deceived. And which act or omission, and that act or omission causes or is likely to cause damage. That act or omission. What act or omission? Intentionally, by deceiving somebody, intentionally induces that person to do something, do an act or omit to do act, and such act or omission causes or is likely to cause damage or harm to that person. Such act or omission causes or is likely to cause harm to that person in how? In body, mind, reputation, or property is said to cheat. So very important definition. Cheating is very important. You should understand it that is word by word. Whoever by deceiving any person, first one person is deceived and thereby fraudulently or dishonestly induces to whom? The person so deceived, what? To deliver any property to him or any person, or that the person or to consent that any person, or to consent that any person shall retain any property, or whoever by deceiving any person fraudulently or dishonestly intentionally induce the person so deceived to do or omit to do anything which he would not do or omit if he was not so deceived, and which act or omission causes or is likely to cause, either causes or is likely to cause damage or harm. That is what is either damage or harm. How? To any person. Damage or harm to any person. How? In body, mind, reputation, or property is set to cheat. This is cheating. Explanation provides A dishonest concealment of facts is a deception. What is deception? Dishonest with a intention to cause wrongful gain and wrongful loss to another, somebody conceal certain facts. Dishonest concealment of certain facts is deception. Within the meaning of this section 415, you will go through the illustration. There are a number of illustrations in this section. What are those? You will be more, your mind will be more clear on your concept will be clear. What is that? A. A by falsely pretending to be in civil service. A is not in civil service, but falsely pretended to another person that is in civil service. Intentionally deceive judge, saying that I am in civil service, and thus dishonesty induces judge to let him have on credit goods for which it does not mean to pay. Induces Z to give some goods to him on credit, but he has no means to pay. And thereby, but because of intentional deception, intentionally deceiving the fact, he knows that he is not a civil servant. He induces Z that he is in civil service. He can repay the price of the goods if he supplies those goods to him, if he sells those goods to him on credit, but he has no means to pay, then that is cheating. So A cheats. B. A by putting a counterfeit mark on an article intentionally deceives Z into a belief that this article was made by a certain celebrated manufacturer. Suppose a particular washing machine is not made of a particular reputed company, but another person falsely put a counterfeit mark on that washing machine and thereby induced another to believe that the particular washing machine was the make of a particular reputed company, and thereby he induces that person to purchase that washing machine. So that will be treated as cheating. A by putting a counterfeit mark on an article intentionally deceives Z into a belief that this article was made by a certain celebrated manufacturer and thus dishonestly induces Z to buy and pay for the article. He cheats. A cheats. Simply inducement is enough. May not be transferred. That is cheating. A by exhibiting to Z a false sample of an article. False sample of a particular article was shown to A, so that false sample to Z and deceives Z into a belief that this article was made by a certain, that is a sample intentionally deceives Z into believing that the article corresponds with the sample. The article which is selling to Z, that corresponds with the sample, and thereby dishonestly induces Z to buy and pay for the article. A cheats. E by tendering in payment for an article a bill on a house with which A keeps no money. Suppose A purchased a particular goods from a particular shop and he gave a check. Gave a bill of exchange is a check. Check means what? Check is a bill of exchange drawn on a banker. So here A purchased certain goods and gave a check, knowing that there was no money in his account. So here, and that check will be dishonored, then that will be treated as cheating. A by pledging as diamond articles which he knows are not diamond. Suppose A pledged a gold ring, knowing that was not made of gold, but only there is a coating of gold, and thereby he pledged and induces somebody to give some money, keeping that goods, keeping that property in security. That is to be treated as cheating. A intentionally deceives Z into a belief that A means to repay any money that Z may lend to him, and thereby dishonestly induces Z to lend his money. A has no means to repay the money, but intentionally deceives. Deception is very important, and thereby induces Z to lend money to him, or knowing that he has no means to pay. That dishonestly induces Z to lend his money. A is not intending to repay. It is just cheating. So here A intentionally deceives Z into a belief that A means to deliver to Z a certain quantity of indigo plant, which it does not intend to deliver. This is very, sometimes this illustration comes as a direct problem in many examinations. A intentionally deceives Z into a belief that A means to deliver to Z a certain quantity of indigo. Indigo is a color, indigo plant, which it does not intend to deliver, and thereby dishonestly induces Z to advance money upon the faith of such delivery. A cheats, but if A at the time of obtaining the money intends to deliver the indigo plant, has the intention to deliver the indigo plant, and afterwards breaks his contract and does not believe it, he does not cheat. Here, but he is liable only to a civil action for breach of contract, because A intentionally induced deceives Z, or if there is no deception, A had only intended to sell his indigo plant at a particular price, thereafter he did not keep his promise, so that will not be treated as cheating. That will be treated as breach of contract. A intentionally deceives Z into a belief that A has performed a part of a contract made with Z. Intentional deceit, which he has not performed. He has not performed intentional deceit something and induces him to perform, that is a particular contract which he does not perform. And that by dishonestly induces Z to pay money, he cheats. A sells and conveys an estate. Estate means land. A sells and conveys an estate to B. A knowing that in consequence of such sale, he has no right to the property. He knows that he has no right to the property. Boy is sold, conveyed that property, that land to another, right to sell or mortgage that property to J without disclosing the fact. Without disclosing the fact that he has no right, he sells that property to J. Here, the fact of the previous sale, and there was a previous seller conveyance to B, and received the purchase money from J, A cheats. You should understand various cities. Cheating is very important definition. If you do not understand it properly, you will be confused. What is cheating? Cheating, for cheating, there should be two ingredients. First, there is a deception, there is a fraudulent or dishonest inducement to the person who has been so deceived, either to deliver any property to any person, or to give consent to retain any property by any person, or intentionally induces that person to do or omit to do certain thing which you would not have done or would not have omitted to do had he not deceived. And if that such act and omission what causes or is likely to cause what damage or harm, these two things, such act or omission has causes or is likely to cause harm or damage to any person, to that person in this body, mind, reputation, or property is said to cheat. Sometimes there is a confusion whether a person that conceals certain facts and thereby induced another person to marry, and thereby he married, and also whether this that will be treated as cheating. If there is a dishonest intention, fraudulently, dishonestly, he can deceive certain fact and thereby obtain his consent. Had he not deceived, he would not have that the woman they would not have consented for the marriage. After marriage, there is certainly that is a damage or harm to his body. That is mind or reputation. That is mind that is a certain mental agony. Also things will come under the provisions that is applicable, that will be treated as cheating. Cheating by personation. Section 416. What is a person is said to cheat by personation if he cheats by pretending to be some other person. X pretending to be Y, he cheats Z. That will be treated as cheating by personation. Or even in a fictitious name, he cheats somebody. That will be also treated as cheating by personation. What he says? A person is said to cheat by personation if he cheats by pretending to be some other person, pretending to be some other person, cheats another person, or by knowingly substituting one person for another. What it says? A person is said to cheat by person. What is cheat by person? If he cheats by pretending to be some other person, if he cheats by pretending to some other person, or if he cheats by knowingly substituting one person for another, pretending to one person, or he cheats knowingly by substituting one person for another, or representing that he or any other person is a person other than he, or representing that he or any other person, he or any other person is a person other than he, or such other person really is. He is not the real person. Other person is not the real person. But thereby he cheats. That will be treated as cheating by personation. The offense is committed whether the individual personated is a real or imaginary person. Even in the name of an imaginary person, if somebody cheats, that will be treated as cheating by personation. You see, a cheats by pretending to be a certain rich banker of the same name. There is two persons in the same name, Mr. This X. There are two persons in the name of X, but a person, one X, cheated another person pretending to be another person who is a rich man. A cheats by personation. A cheats by pretending to be B, a person who is deceased. Even B is dead. A cheats pretending to be B. Here, that is cheating by personation. So again, at the cost of repetition, you should know that a person is said to cheat by personation if he cheats by pretending to be some other person first, if he cheats by pretending to be some other person, or if he cheats by knowing substituting, he cheats by substituting one person for another, or if he cheats by representing that he or any other person is a person other than he or such other person really is. Punishment for cheating, 417. Whoever cheats shall be punished with imprisonment or either death for a term which makes him to 1 year or with fine or with 418 and 420, 419 are aggravated form of cheating. Cheating with knowledge that wrongful loss may cause to person whose interest offender is bound to protect. The offender is bound to protect somebody's interest, but he cheats with that knowledge that he is bound to protect somebody's interest. Whoever cheats with the knowledge that is likely thereby to cause wrongful loss to a person. Whoever cheats with the knowledge that is thereby cause wrongful loss to a person whose interest he is bound to protect. Knowledge that he is likely thereby to cause wrongful loss to a person whose interest in the transaction to which the cheating relates. Only in the transaction in the cheating relates, he was bound either by law or by legal contract or to protect. If somebody is an agent, he cheats in a transaction, thereby causing loss to another. So what is this? 418. Whoever cheats with the knowledge, a person cheats with the knowledge that he is likely thereby to cause wrongful loss to a person whose interest in the transaction to which the cheating relates. Whose interest in the transaction in the cheating relates, he was bound either by law or by legal contract to protect. shall be punished with imprisonment of either distance for a term which may extend to 3 years or with fine or with both. What is this? That is the act by which cheating was committed. That was done with the knowledge that he thereby likely thereby to cause wrongful loss of the person whose interest he was required to protect in that transaction. That is section 418. 419, punishment for cheating by personation. Whoever cheats by personation shall be punished with imprisonment for either distance for a term which makes 3 years or with fine or with both. Suppose X is not a real candidate, but in an examination, he pretends and appeared in an examination in the name of another person. That is cheating by personation. Whoever cheats by personation shall be punished with imprisonment for either distance for a term which may extend to 3 years or with both. 420, everybody knows, it's a very common section. What is cheating and dishonestly inducing delivery property? Whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person. Whoever cheats, cheating that is as defined in section, simply inducing delivery property. Whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person or to make, alter or destroy the whole or any part of the valuable security. Dishonestly induces that person to deliver property or to destroy or the whole or any part or to make a valuable security. What is valuable security? Valuable security is a document whereby the right is created, extinguished, extended, etc. So here section 420, what it provides, whoever cheats, first there is cheating, and thereby dishonestly induces the person deceived, what? To deliver any property to any person. Deliver any property to any person. Or to make, alter or destroy the whole or any part of the valuable security. Cheats and thereby dishonestly induces that person to destroy any valuable security, to alter any valuable security, or to make a valuable security, or anything which is signed. Whoever cheats and thereby dishonestly induces that person to anything about any person, what? So deceive. To do anything which is signed or sealed and which is capable of being converted into a valuable security shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Section 420, it is aggravated form of cheating. First, there is the cheating. Whoever cheats, deceiving something, inducing another person to deliver property, and thereby dishonestly induces that person deceived to deliver property. Then section 420 is punishable section, or any property to any person, or by so deceiving whoever cheats and thereby dishonestly induces that person to make, alter or destroy the whole or any part of valuable security, or anything which is signed or sealed and which is capable of being converted into valuable security shall be punished with imprisonment for either description or a term which may extend to 7 years and shall be liable to fine. 421. A fraudulent deeds and disposition of property. What section 421 says? Dishonest and fraudulent removal or concealment of property to prevent distribution among creditors. This is another a property offense. What is this? How? Suppose there are many creditors. Some creditors are there. They have filed a suit for recovery of their dues. Whoever dishonestly or fraudulently removes that property or conceals that property, what is that? So that the creditors will be deprived of to get their money, get their dues. Section 421 will be applicable. Whoever dishonestly or fraudulently you should understand as defined in the definition. dishonestly causing wrongful gain, wrongful loss, and fraudulently with intention to defraud but not otherwise. Whoever dishonestly or fraudulently removes, conceals, or delivers to any person, or transfer or cause to be transferred to any person. Somebody transferred that property, cause to be transferred to any person without adequate consideration, only without adequate consideration, any property. What is that? Intending thereby to prevent or knowing it to be likely that you will thereby prevent. Intending to prevent or knowing is that you will thereby likely to prevent the distribution of that property. What is that? Whoever dishonestly or fraudulently either removes that property, conceals any property, delivers any property to any property, transfers any property to any person without adequate consideration. But for intending thereby to prevent or knowing it to be likely that he will thereby prevent. Intending thereby to prevent or with knowing that he will thereby likely to prevent the distribution of that property according to law among his creditors. X as a creditor, many creditors, he remove that property, transfer that property, conceal that property, so that to prevent his creditors or to deprive, that means prevent their creditors for distribution of that property or the creditors of any other person, even any other person, if another person's it transfers, shall be punished with imprisonment, either description for a term which may extend to 2 years or with fine or with dishonestly or fraudulently preventing debt being available for creditors. Similarly, whoever dishonestly or fraudulently prevents any debt or demand due to himself or to any other person from being made available. Any debt which has taken, that will be prevent that person to be made available according to law for payment of his debts. It is here, whoever dishonestly or fraudulently prevents any debt or demand due to himself, any demand, suppose I am entitled to get some debt or demand from himself, whoever dishonestly or fraudulently prevents any debt or demand due to himself, that debt or due to himself, or to any other person from being made available according to law for payment of his debt. I have some debt, I am entitled to recover some debt from another. Or then if I prevent that person not to give me, pay that money so that my creditor will not get, Section 422 will be applicable. Whoever dishonestly or fraudulently prevents any debt or demand due to himself, any demand due to that person or to any other person, from any other person who is due from being made available, that debt will not be made available according to law for payment of his debt, for a payment of that person's debt, or the debt of such other person, shall be punished with imprisonment either discussed for a term which may extend to 2 years or with fine or with both. 423. Dishonest or fraudulent execution of deed of transfer containing false statement of consideration. This section is very commonly touted. Very often that is not, this offence is committed by any person. Suppose that is a person who has to avoid stamp duty. He is sometimes the transaction or the consideration money is shown as a lower consideration money. Exact consideration, exact price is not shown in the documents. Section 423 is applicable when with the dishonest or fraudulent execution of deed of transfer containing false statement of consideration. What it says, whoever dishonestly or fraudulently signs, executes, or becomes a party. Dishonestly or fraudulently signs, executes, or becomes a party to any deed or instrument which purport to transfer or is subject to any charge any property, which purport to transfer and charge any property or any interest therein, and which contains any false statement, dishonestly and fraudulently becomes a party to a document, signs a document, executes a document, or creates a charge by virtue through a document containing any false statement relating to the consideration. considering a false statement related to the consideration for such transfer or charge, or relate on the person or person for whose use or benefit it is really intended to operate, shall be punished with imprisonment of either discretion for a term which maximum to 2 years or with both. 424. Dishonest or fraudulent removal of concealment of property. This is also whoever dishonestly or fraudulently conceals or remove any property of himself or any other person, or dishonestly or fraudulently assist in the concealment or removal of property, or dishonestly releases any demand or claim to which he is entitled, shall be punished with imprisonment or either discretion for a term which makes to 2 years or with fine or with both. This is we have covered so far section 424. Let us only discuss what is mischief. Mischief has been defined in section 425. Whoever with intent to cause or knowing that he is likely to cause. Whoever with intent to cause or knowingly that he is likely to cause. What? Wrongful loss or damage. Wrongful loss or damage to the public or to any person. Whoever with intent to cause. That is first intention. Whoever with intent to cause or knowing that he is likely to cause. Direct intention, knowing that he is likely to cause. What? What is that? Wrongful loss or damage. Two things. Either wrongful loss or damage to the public. Wrongful loss or damage to the public. Or to any person. Or to any person. What is that? A person with intention to cause. Or which is likely to cause. What? Wrongful loss or damage to the public or to any person. Causes the destruction of property. Causes the destruction of that property. Or any such change in any property. Causes the destruction of the property. Or in change in such property. Or in the situation thereof. In the change of that property. Or in situation thereof. As destroys or diminishes its value or utility. As destroys, diminishes its value or utility, or affects it injuriously, commits mischief. Mischief is very important definition. First thing, you go through whoever with intent to cause. First, the intention is to cause, or knowing that he is likely to cause. Either he has direct intention to cause, or the knowledge that he is likely to cause. What cause? Wrongful loss or damage. These are very important questions. Intending to cause, or having knowledge to cause wrongful loss or to damage. To whom? To public or to any person. Public or any person. Causes destruction of that property. First, destruction of that property. Or any such change in the property. Causes destruction of the property. Change in that property. Or in the situation thereof. As destroys or damages. Situation thereof. Causes destruction of that property. Change in that property. Causes destruction of that property. Change in that property. Or in the situation thereof. Situation where that is there. In situation thereof. The situation, because of the situation is such as destroys or diminishes its value or utility. As destroys its value or utility. Or affects it injuriously. Commits mischief. Best example is, suppose you have parked your car X with an intention to cause damage to your car or wrongful loss to your car. Just scratch, causes a scratch on the car, either on the glass or on the body of that car. Thereafter, so here he commits mischief because with the intention to cause, what is that? Damage or to you, to another person, causes destruction of that property, or in change in that property, or in the sequence of thereof, as destroys, diminish its utility, or affect that injuriously commits mischief. Suppose somebody, you have your car in the park, somebody punctured your car, the tire of your car. So here he commits mischief. That is section 425. Whoever with intent to cause, or knowingly that he is likely to cause, wrongful loss or damage to the public or to any person, either wrongful damage or loss, wrongful loss or damage. See, every word has a very, you should understand. Whoever with intent to cause, or with having knowledge to cause, likely to cause, or knowing that he is likely to cause, wrongful loss or damage. To whom? Either to the public or to any person, or just destruction of that property, or any change in that property, or or in situation thereof, a change in property or the change of the situation of the property, so which destroys or diminishes the value of or utility, which destroys or diminishes the value of or utility of that property, or affects it injuriously, commits mischief. Explanation 1 says, it is not essential to the offense of mischief that the offender should intend to cause loss or damage to the owner of the property. It is not essential that the offender must have intention to cause damage or wrongful loss to the owner of that property, injured or destroyed. It is sufficient if the intends to cause or know that he is likely to cause wrongful loss or damage to any person by injuring that property, whether it belongs to that person or not. Explanation 2 says, mischief may be committed by an act affecting property belonging to the person who commit the act, or to that person and others jointly. Suppose X and Y jointly own a particular car, jointly are the owner of a particular cow, but or a particular property, but X with the intention to cause damage or loss to another person, though it is affecting his own interest. That is, if it causes destruction, that will also be treated as mischief. So section 2 says, mischief may be committed by an act affecting property belonging to the person who commit the act, or to that person and others jointly. So far we have understood the definition of mischief. In the next class, we'll again discuss what is mischief with illustration. You should understand what is mischief. With intent to cause, or having with knowledge to cause, likely to cause wrongful loss or damage, either to the public or to any person, or destroys that property, changes the situation of that property, or changes that property, which destroys or diminishes the value of that property, or affects the injuriously commits. Thank you.